it's always nice to come and address the individual pain initiatives. I learn a lot, and as a lawyer, that really helps me be an advocate for you. And I have to, my good friend Bill McCarberg probably divorced me over this summer. I owe him a chapter for a book of his, and there were so many legal regulatory changes in addition to some personal issues that I just decided to get him a card that has an explanation in it of the way the lawyers talk. So you may not be able to hear it real well, but you'll get the gist of it. Ready?
I'm depressed, I get wet, my face broke out, I'm nauseous, I'm constipated, my feet swelled, my gums are bleeding, my sinuses are clogged, I got heartburn, I'm cranky, and I have gas.
And I have gas. Plus the law changed, Bill, and I think it was so important to make the legal regulatory changes in a book chapter to make it accurate. And some of you may have patience like that too, which all the more makes that an obvious application to your daily stuff. We're going to rocket through some current legal regulatory events, and in my 7 years of working in the pain community directly after I left my role as a federal prosecutor, assistant U.S. attorney with the Department of Justice, I have never had a year so full of legal regulatory changes as this year has been. And it has been very difficult to keep up with it. It would seem like no sooner would I finish something and then the law would change. And even though we would have hints about these changes, some of the changes were not really predictable. And then some of them are a result of the economy that we're in, and then some unanticipated issues with marketing and whatnot. So we're going to talk through a couple of these things and give you kind of a top-level view. For purposes of this program, there we go. These are my disclosures, and these are current disclosures. Some things rotate over the 12-month rule, but I do speak and serve as a consultant for many different companies. And I'm not going to be using anything particular in here to violate any CME rules. The real learning objectives here are to identify some key initiatives in pain regulatory policy in federal and state jurisdictions that impact your practice. And before we started here just a minute ago, I've heard a couple of questions and some issues, especially one that relates to a malpractice carrier in the area. And I can address some of those comments generically, and I think I can provide a couple of suggestions that may help you deal with those events. That's happening also in Nevada in a very particular way, and I think that really puts practitioners in a dilemma of complying with clinical and regulatory guidelines to treat pain and to take reasonable steps to prevent abuse and diversion, or walking in the face of the malpractice carrier that says we're not going to let you do this, we're not going to cover you, we're not going to back you up, when what they're saying can actually put you in violation of clinical standards of care and regulatory guidelines. So that's a really tough road to walk, but it is an area that myself and some of my partners focus on, and so we can cover that as well. I wanted to tell you that I intended to give every one of you a CD-ROM with kind of a notebook on there. And then when I asked Kay the number of people that were coming, and she told me 190, I thought, there's got to be a better way than me sitting there and printing off, because I would be the one doing it, which I don't mind, that many CDs. So what I have done is created what I call an intranet for you. And you're going to have to do a step to be able to get access to it, and there's no money involved, but the access will involve somebody maybe should start a sheet. Let's start it over. Who's got a piece of paper that we can start it with?
What do you need, paper?
Yeah, I need it. Well, we can do it, or you can individually do it. Let's do it that way. I'm going to need your first name and your last name, an email address, and a contact telephone number. All right. I don't need a physical address. I'm not going to market it to anybody. I'm not going to market you or anything like that. But I need it in a legible fashion to get you registered on this intranet, because here's what's going to be there for you. I did this for the Delaware Pain Initiative and created basically a library of key materials. Instead of having to exchange things over an email or find it on a disk where it might be outdated in the next month, I created a living intranet for you to access to go and get current information. So I've got my comments to the FDA on the opioid REMS, which we'll discuss, my comments that I had to submit yesterday to the Centers for Medicare and Medicaid Services over some proposed changes in laboratory code and laboratory services that are really are going to have significant ramifications in the pain community. Some of the key DEA materials, and this is that site live right now. Once you get where you're logged in and have a passcode to it, you can go in and look at an overview, post a message, read these materials, print them off, that sort of thing, and use them in your training. And the only thing that I ever ask you to do is not change anything if the content it has kind of a legal regulatory tone. Because if I prepare something and you use it in your training and you're not a lawyer, by changing any words just to make a slide look nicer, you might actually change the context of what's being taught. And that puts you in a bad position and me in a bad position. So that's our agreement for the use of this site. And of course, no derogatory comments. You can do constructive criticisms, until you're satisfied and the cows come home. So that's what it's about. And I hope you will take advantage of this. In the Delaware Pain Initiative, we have both law enforcement members and practitioners and folks from the American Cancer Society, and I don't prevent any of those folks from having stuff. I kind of monitor what's going back and forth on the internet, but I really think this is a neat way to stay informed, stay current, and develop some relationships that you might not have. I would also say don't sit there and write to the entire public that you're having a specific issue and here are the facts of your case. If you need to do something like that, do that offline, because this is, again, it's only accessible by those with permissions, but it is a rather public forum for that. So that's what I did there, and I hope that you will take advantage of it. Let me go back to my slideshow and not mess it up. Hang on a minute.
While you're doing that, if I have all of your email addresses and your phone numbers, and if I can send out a blanket email that if you don't want it, you need to say no, and then I can just get that information.
Yeah. You're not going to be marketed for anything. I don't have time to do that. I don't even like doing it. So I just want to make sure you get information. That's my goal. So here we are. The Fundamental Pain Regulatory Policy Framework has at its platform federal materials. And then you stack on top of that state materials from your licensing boards and your law, your Controlled Substances Act, and influential clinical guidelines, as well as regulatory guidelines and policy statements. How many of you are not from Montana? Can you yell out the states where you are? Washington. Where's the other one? Nevada. Kansas, Wyoming. Okay, I'm fairly familiar right now at the top of my head with some of the materials in all of the states referenced. And, there are similarities all the way through state pain regulatory policy. And I see June Dahl, my friend in the back, and she and her colleagues have just been truly instrumental in trying to level the playing field for pain regulatory policy so that we have at its core two principles that should not be viewed as competing, but should be viewed as the goals of all practitioners, and that is access to quality pain management, which would include the use of controlled medications where there's a legitimate medical purpose, and then of course the overlay of the regulatory obligation, and of course an ethical and professional obligation to take reasonable steps to prevent the non-medical use of controlled medications that you prescribe or that your patients may have access to through family members, etc. And it comes down to this. Essentially, we're dealing with these principles in an environment that tends to spark some controversy when you're talking about government involvement in pain management, as the FDA has so inserted itself through some new programs called opioid REMS. How many of you are familiar with opioid REMS? Okay, well, June, I would have expected that. We're going to cover a little bit about that today, but this is a new thing from the FDA. We'll get there in just a second. If you haven't, for the Montana folks, if you haven't read your position papers on using controlled medications to treat pain and also the termination of the clinician-patient relationship, you should do so. They're readily available on the board's website. I went there today, and I'm sure the nursing boards and the pharmacy boards also have similar papers, but it doesn't matter really what your licensing is. If you're in the pain community, then these things should be part of your regulatory compliance book in your practice and used in case, for reference purposes as you design compliance policies, but also as any kind of panic material should the worst happen and you get a visit from a board investigator, because because you don't want to be looking for that stuff after the fact. You want to be proactive about your involvement in regulatory compliance. So Montana has one. They adopted this one in January of this year, and then they did some modification recently, and it tends to track the Federation of State Medical Boards model policy on the use of controlled medications to treat pain. And notice that this doesn't say opioids, okay? We all get fixated on opioids, and there are clinical guidelines from pain societies like the American Pain Society, American Academy of Pain Medicine, that deal directly with the use of chronic opioid therapy for the treatment of non-cancer pain. But in this instance, and from a regulatory perspective, the regulatory authorities, they don't really distinguish between opioids and benzodiazepines and other controlled medications. This is a law at its platform, the Federal Controlled Substances Act, that deals with all controlled substances. And the state laws deal with all controlled substances. And sometimes licensing boards will focus on position papers that might deal with a particular issue in a state. For example, Kentucky has a benzodiazepine guideline or guidance paper to its clinicians. When clinicians are using benzodiazepines long term, they are to comply with the suggestions in that statement or show a good reason why they are not going to comply with it, maybe an update in science or things like that. Well, this is controlled substances. And from a lawyer's perspective, if you don't get these fundamental issues like the words, the controlled substances versus opioids or versus narcotics, then your whole platform will be askew as you write forms for your practice and as you teach others. It's important that you learn to incorporate the key phrases of legal regulatory material to really show individuals who look at documentation from your practice, if you're an expert and you testify and you want to do education on these topics, these kind of things tell people you get it. You get it, and you've taken time to read the materials, and you really are committed to addressing the principle of balance that I mentioned when we started. Treating pain, providing access when controlled medications are appropriate, and taking reasonable steps to prevent abuse and diversion or non-medical use. So remember that as you read through any materials, that you look for the phrases, and if this document says that the board encourages practitioners to use a treatment agreement if the patients are at high risk for substance abuse. It doesn't say use an opioid contract. It doesn't say use a narcotic contract. It says you're recommended to use a treatment agreement. And that language is critical if you're sitting in front of a jury that's evaluating you as a practitioner or a hearing board, and they splash the stuff up on the courtroom wall, and there you go. Your lawyer can say, look, they do understand it. They've worded their materials consistent with the state materials. They've thought about not labeling patients. They've thought about the tone of what they write and give out to people. But if you don't do those things, then me as a lawyer or anybody else can't make those arguments very well. And that's really where my perspective is as we go into trying to understand more about the implications of the law on your daily medical practice. This one is the Montana position paper on terminating a patient relationship. Notice it doesn't say firing a patient. Notice it doesn't say, and it could say something a little nicer, withdrawing from care. That would also be an appropriate term. The position paper here is one that is used frequently in different states. Not all states have this position paper, but all states have some reference to this through their ethical codes, and all of those codes track back to the American Medical Association's Code of Ethics for practitioners, okay, for physicians in this situation. Here, this applies to anybody that's got the practitioner-patient relationship, even though the language says physician here. And what's really critical is that this talks about the AMA's Code of Ethics. It talks about the obligation to give notice, and it talks about circumstances where you might terminate the relationship. You're not terminating the person. You're terminating a relationship for very specific reasons. And, the AMA Code of Ethics on withdrawal from care or terminating the relationship requires reasonable notice. which is at least 30 days, and some states will go a little more strict and go to 45, requires a written notification of the intent to terminate with a statement of the reasons without labeling the patient. Dear Jane Doe, you're an idiot and you're fired is not acceptable. Okay? I have seen letters very close to that. Maybe not saying you're an idiot, but saying we're firing you from our practice because you're an idiot. And that's the kind of stuff that just doesn't sit well with anybody, and it's certainly really indicative of an improper ethics platform. So here, this position paper is very good to read. I've already uploaded it to the intranet and intranet, I'm saying, and it gives you some ideas about terminating the relationship. And it tells you that the real question to answer here is care futile if the patient remains in this non-compliant capacity? And in many instances, when you deal with patients with chronic pain and people that are constantly asking for early refills despite the adjustments that you make in their care plan, that are going to other practitioners and getting controlled medications, certainly that continued behavior would make it very difficult to follow the original principle of balance, and that is providing the quality care while balancing with the prevention or guarding against the misuse and abuse, etc. So this is a relevant document and an example of some regulatory policy that does affect pain management as well as any other type of medical practice. So we have a current and legal and regulatory environment that calls the prescription drug abuse and diversion problem in this country a public health crisis. But we have a competing environment with the undertreatment of pain and it being a public health crisis with, missed work days and all kinds of expenses to health systems. And when you have a bad economic environment overall, that can really be tough on everybody because, patients are trying to get and stay in their jobs so they don't lose them and they can care for their families. They put more pressure on you to make a care plan that helps them, achieve those goals. And then that puts more pressure on you because you know that the government, Federal Food and Drug Administration especially, is looking into controlling some of the access and education surrounding opioid medications in particular. And that's that opioid REMS stuff that we'll get to. So here is your battle for balance. And everything that you do, from writing down your rationale for prescribing or not prescribing, it should be in fulfillment of or demonstrating balance, all right? So what you think when you prescribe or withhold a prescription is really relevant to demonstrating compliance with these regulatory materials and, of course, with clinical guidelines that lay over the top of all of this. So the mindset is really critical here. So you've got the give or take lessons. I always like these pictures. Or do we have a problem patient? And a problem patient can be a lot of things. I have all these medicines, but I'm afraid to take them. My family thinks I'm going to turn into some sort of monster. Or I have all these medicines, and they're my medicines, and I don't want to give them back, even if you are going to change my medication plan. Or, these are my medicines, and I really need them in spite of the fact that I don't have much pain, or so on and so on and so on. How many of y'all have patients that fit into at least one of these categories? Of course you do. Be silly. Now, these are also some perspectives on safe practices. From a compliance and regulatory perspective, I would always recommend the initial use of such things, but I think the real way is silly. This is a silly slide, but you want to have good, solid documentation. In a chapter that I'm writing, I wrote that, documentation is perhaps your lifeline to demonstrating that you get it, that you understand the principle of balance, that you do care about your patients, that you are going to treat pain and not put yourself in a position of being sued for undertreating pain, because that happens too. It's not just about overprescribing. It's about staying where it's appropriate for the individual patient in front of you at the very moment, and not about, I'm just not going to treat pain because those people are just too much trouble. I've had many family practitioners tell me that to my face. This is too much trouble, and I'm a pain patient. I'm a chronic pain patient. I'm in a lot of pain right now standing up here in front of you, and I don't ever want to be told that I'm too much trouble to be taken care of. You can monitor my Coumadin. You know, you've dealt with me living through 2 pulmonary embolisms and a clot in my brain. You've lived with the filter that's been implanted. You handle all that for me, but you're not willing to handle the little bit of medication that gives me some comfort. And I'm not accusing you. I'm just saying the people that have said those things to me personally, I'm kind of like, wait a minute. You need to understand that there's a whole other world of potential adverse legal action out there that does take place. And you don't hear people talk about this all that often. And it starts something like this. Dear Licensing Board, my name is Jane Doe, and I'm a 56-year-old female who lives by myself, and I work and I support 25 kids. And I went to my family doctor, and I've been seeing this doctor for 25 years, and I've never had any issues. And all of a sudden, my hips start hurting, my back starts hurting, my body's giving out, and I asked for some medication for pain management. And my doctor said, no. And my doctor said, we don't treat pain. And my doctor said, go see a pain specialist. And I told my doctor I couldn't get into the pain specialist until 8 months down the road. And I told my doctor that I didn't really want to have injections because, remember, you told me I couldn't do that kind of stuff ever because of this little blood clot problem that I have, because you didn't want me going off my Coumadin for some of these procedures or anything like that, that it would be very dangerous for me to do that. And then you said, well, we could manage some of that stuff with, the doctor said that they could manage it with Lovenox injections and things like that. And that I said, I don't want to pay for that. That's really expensive. I got to take care of my 25 kids. And so what happens if something similar, as crazy as that sounds, happens to the licensing board? They investigate it. They investigate it no matter what the claim is, because that's their job. They make the initial inquiry, and that's where the stomach aches start. And so the stomach aches start there no matter who the patient is and no matter what their claim is. And it's really my job to help you understand that you can balance these things out in your practice, and you can have good documentation and demonstrate compliance with very little headache in terms of the decisions that you ultimately make. When the decisions are designed for the best interest of the patient, and you can back it up with generally accepted standards of care to say yes or to say no, or to make the referral, or to control the supply of medication, or to choose one type of medication over another, then you're on solid ground legally. And when you're on solid ground legally and you've done these things, you give me the arrows, or a lawyer like me the arrows, to shoot back and to make a difference on your behalf and on behalf of the patients that you treat. Because if you don't stay in business, then many patients will suffer. And if you give up on this area of pain management, many more, including probably some of you individually and your family members, will have issues. So always remember that adverse legal actions go all different directions, and certainly there are some garbage lawsuits that are filed against you that really suck the life out of the healthcare system. And I am an advocate for tort reform. I think it's unconscionable that we have some of these lawsuits the way that they do without a good faith basis and a proof up front before they even get into the newspapers, because I think that's where so much damage has been done, not just in this area, but in other areas of medical practice. So this is the mentality I'm about to take. I get accused of being this way all the time. You know, I come from a prosecutor background, but my intent and my heart are clearly on your side. And so the things that I'm going to show you, some of them none of us can control. They happen, and the government's going to keep doing what it's doing. You have to keep doing what you're doing in response to take care of people. So here we go. It's important to understand the critical distinctions in approach to clinical and regulatory compliance. When I was a regulator, when I was a prosecutor, and I first started handling these cases, I had a checklist mentality. And I had they either did it or they didn't do it mentality. They either didn't do the physical exam or they did it. And there wasn't much in between. And then I started having exposure to clinicians like you all across the country. And my mind as a prosecutor started growing. And I went and became very concerned about the fact that there appeared not to, and this was back in 2001 and 2002, at the very beginning of the decade of pain control and research, that we weren't educating properly. We had to include the legal component to our education on pain management if we were all going to survive this crazy ride that we're on. And that slowly took hold. But in my mind, it was on full panic mode because I'm sitting there with my colleagues in the Department of Justice judging me for wanting to go hire medical experts in pain that could help me understand your language. I saw that as my duty, I saw that as my responsibility, and thus began the genesis of Jennifer shifting to this side where you all are. And of course, I can't accurately capture all of your thoughts on here, but your mindset is different. You're dealing with what you can get in your system, the realities of lack of insurance coverage or inadequate insurance coverage, unemployment, people that want to use medicines and not have procedures, people that insist on telling you the names of the medicines that they want, people that can't have access to some of the training that's necessary to go forward from a clinical point of view, where you have a mentoring capacity, where you work with other clinicians. That would be the most ideal thing in our world, but we don't have that everywhere. You have evolving standards that are limited by access issues, and your treatment is often based on your exposure to current information. Many of you said, some of you were familiar with opioid REMS, but most of you were not. Now, at the end of this talk, you're going to have some more familiarity, and that may impact how you go about selecting medicine, how you view patients. And my intent, of course, is for you never to deny appropriate treatment. But if I don't tell you these things, then we can't prepare for some of these changes going forward. And that has been the problem with some of the pain education in this country. We haven't done enough how-to teaching. We've done a lot of, here's what you got to do, here's what's required, here's what's this, here's what's that. But we need to take a little more control and go hand by hand. And many of you that I know in this audience are big advocates of education and are how-to teachers. So remember this dichotomy here, and then also remember that there's a way to go down the middle and understand the intersection of law and medicine. So now I want to show you the key events in 2009, just this year, from what's happened. It started off with a bang. A DEA administrative opinion came out in January. And then the clinical guidelines from the American Pain Society, American Academy of Pain Medicine were published, and by their very statement, they apply or are intended to apply to any practitioner that uses chronic opioid therapy to treat chronic non-cancer pain. By their definition, not mine. Then there's this DEA proposed rule on disposal of controlled medications by non-registrants. Patients that come in, they're not using their medicine up, and they've got it hanging out in the medicine cabinet, and it's time to get rid of it to be safe and to try to promote medication safety. Well, what do you do with it? You can't pollute the water because it'll poison the fishes. You don't really want to keep it in your practice because you get tempted to either give it out to people that can't afford it, you don't have a dispensing registration, it becomes a big nightmare. DEA put 117 questions to different pain community stakeholders in this proposed rule. I can't even begin to cite all the questions that are still unanswered from the DEA on this topic, so you can see the magnitude of what we're dealing with, and we're hoping that'll come out by the end of the year and make some sense of it. They've started take-back programs across the country. Have y'all had those yet? Where there's medication take-back and they go and they incinerate them. And there's a whole issue about, reverse distribution, because DEA's system is a closed system for controlled medications in this country. You have to have a permission slip to go through it and to touch the controlled medications from the very manufacturer all the way through the ultimate user. And this kind of stuff, completely derails the system when a non-registrant like me says, what do you want me to do with my medicine? Give it out? Put it on my family intranet in case somebody else needs it? They do that in Tennessee, by the way. Crazy things like that. They have to answer those questions, and they don't even know where to start. Then in July of 2009, there was a kind of a sneaky meeting held at CMS dealing with proposed changes to laboratory services codes that tie back to urine drug testing in all practices at the point of care and at the laboratory, and I'll go into that in a second, and very generally. Then we have the opioid REMS that's been hanging on since '07, and we have one of our first publications with a new rapid onset medication for breakthrough pain management in a cancer pain patient population, and then finally medication education initiative. So it has been a big year and continues to be that way. Now let's look quickly at the IER opinion. First of all, this is a DEA administrative opinion, meaning DEA was acting as an administrative agency that registers practitioners to prescribe controlled medication. So they issue this opinion, and the way that the law works in this area is that the facts of this opinion and what comes out of it is limited to that case and isn't always grabbed for precedent into other cases. But as a lawyer looking at this, there are some really valuable teaching lessons or points in here that I think it's important for you to understand, because it really frameworks the DEA's mentality when they look at action against an individual's registration. So to set the stage here, this is a practitioner who she has her registration back now. She has pain management practice in Florida. Florida is a hotbed of activity, and it's one of the most senseless places to practice medicine, because they put all these restrictions on the clinicians, but they can't get the prescription drug monitoring program funded. So they have this kind of push me, pull you effect down there, and now they're arguing about regulatory rules, and it's a big mess. So she issued prescriptions to undercover officers, and each agent told her that they were not in pain, that they were getting medicines from friends. She failed to perform a physical examination. She falsified the medical record and said she did exams, and she made statements that indicated she was aware that these patients were going to go through the non-medical use. All right? Seeing those facts and taking them as true, wouldn't you think you'd have a little bit of a right to be upset? Well, sure you would. And so they suspended her registration. Not so much because she was practicing pain inappropriately, because she lied to them when they came and revealed the undercover. And that was not a smart thing to do. So in September of '06, they revoke her registration, suspend it for a period of time, and she goes, wait a minute, this isn't really fair. I want to talk to the federal appellate court and tell them that DEA, you should have looked at all of my practices in my prescribing pattern. You should have looked at all of my patients, and not just the 3 undercover visits where I kind of gave a tiny lie about doing physical exams. And so the federal appellate court agreed with her and said, you know what? It was unfair for DEA to overlook in their balancing. They have 5 points they have to consider, and one of them is, is the registrant a danger to the public if they continue prescribing? Words to that effect. So the federal court sends it back to DEA and says, consider her other patients. The DEA says, okay, we'll do that. Here we go. We're going to consider it, and we're going to resolve this case. And here's how we're going to resolve it. She's already been suspended for a year. We're going to give her back her registration with conditions, and then we're going to make these statements that I think are rather significant. DEA's authority to suspend or revoke is not limited to intentional actions of diversion. An intentional action for the practitioner in this case was the writing of the prescriptions to the undercover officers with all of the facts that we discussed. We're having like a light issue back there, and I thought maybe I was supposed to shut up or something. DEA can suspend or revoke even if a practitioner ignores the warning signs that her patients are either personally abusing or diverting controlled medications. And this is the uh-oh. It doesn't have to be an intentional act for DEA to pull a registration. It can be a pattern of ignoring what would otherwise be obvious to other people. So that means people coming in with track marks, or they're jittery, or they've used up their medications 80 times in a row, they're smoking dope, they're using cocaine, and you continue to give them the controlled medications unabated. Now, unabated doesn't mean you stop prescribing necessarily. It means without a check to the treatment plan, without some discussion as to whether there needs to be a change in the treatment plan. And so they also said that registrants are required to put practices in place that adequately protect public health and safety from people that are gravitating toward abuse, misuse, and diversion. and the registrants must acknowledge their responsibilities. And so to her, she gets her registration back. To you, it simply means you need to have a routine, you need to have a plan, and it needs to incorporate this principle of balance to make sure you don't run afoul of this kind of stuff that happens. And many of you will never ever encounter it. They do point out that there's grave and increasing harm to public health and safety caused by the diversion of prescription-controlled substance, and even where the proof establishes only a few acts of diversion, the agency will not grant or continue the registration unless the registrant accepts responsibility for the misconduct. So saying that you lied and, God, I did it right, everything's okay, that's not a good idea. That's a point of, we need to accept that we make mistakes, and we need to make plans for adjusting our practices to deal when we discover those mistakes, to handle those things. Now, clinical guidelines, use of chronic opioid therapy, 37 recommendations, applies to all practitioners, and the directives will likely be used by attorneys and medical experts to gauge compliance. You need to read these things. They basically parallel but explain more than what the Montana guideline says or what your other state guidelines say. It gives a little more bite to what they mean when they say take a patient history, what it means to perform a risk assessment, what monitoring and supervision means from a clinical perspective, and how that rolls into a risk management viewpoint. This is also going to impact informed consent. I'm going to skip over that. You like that? If you die, they'll settle. Okay. Informed consent is all over the place, and it's not the same as a treatment agreement. So let's talk about opioid REMS in the few minutes that we have left. Opioid REMS, here's what it is. A REMS is a risk evaluation and mitigation strategy. It is mandated by the FDA to certain companies that have opioids that are coming through the system, either newly approved or subject to FDA oversight authority based on the label that they already have. So the risk evaluation and mitigation strategy ties back to expanded FDA authority from a 2007 Administrative Act that says, FDA, you get out there, we've got too many overdose deaths, and you need to address medication safe use guidelines with these manufacturers of opioid medications. And the law does not say, FDA, limit it only to rapid onset or limit it to long-acting versus short-acting. It says you decide where you want the boundaries to be. But these are our safe use provisions. So the safe use provisions are patient selection, patient qualification, like are they opioid tolerant or not, follow-up monitoring and supervision, the quantities that might be involved, laboratory diagnostic testing, and the like. And so the law actually sets out this authority, and I have provided a little graphic that kind of explains what these REMS will do, because what happens, let's say company A has a new drug approved, and it's a rapid onset fentanyl-based product that's labeled for breakthrough cancer pain management. In order to use that medication with your patients, you have to go through the training that the company has set up under FDA mandates and approval, and you have to register in order to prescribe the medicine. And the patient has to get into this paperwork, and so does the pharmacy, and there's going to be a closed distribution of it by limiting the number of warehouses that stock the medicine and then ship it out to the patient 48 hours after you join the registry. Now, it won't always be limited that way, but that's how they've started. And the whole idea of this is to really cause practitioners to focus on the patient selection, to focus on what is now, I think, in my opinion, legal opinion, a new clinical standard of care for that particular drug or any drug with a REMS document attached to it, and then, of course, patient follow-up. And that is a two-pronged issue, because if you are required to go through the training and sign a registration form, a REMS document, then the patient is also required to do it. Then it puts more burden on the patient to follow what they sign from a government-mandated perspective versus what you're doing now with these treatment agreements that don't really seem to mean much in many practices. So there is some good to this, but what the bottom line here is that the federal government has not fully described how they're going to apply these REMS programs to other members of the opioid class. So the long-acting medicines and things like that. Nobody really knows, although they're dealing individually with the different manufacturers. This is not the fault of the manufacturers directly. It is, again, FDA mandated, and it's something that you must seriously consider, because you don't want to limit patient access to care by saying, forget it. Government program, government form, I'm not signing it. That's not the right answer. That can result in undertreated pain. And of course, then you don't want to go the other direction and sign something without reading it and then wander into potential off-label prescribing of these medicines by quantity, by the length of time, by patient selection criteria, etc. Because if you do, then there's always this form that you signed that said that you understood the label and that you understood the contraindications were going off the label. And that's what some of these forms say. And if you're not smart and read it, you could be signing yourself into la-la land because of the rest of your practice. So be very careful. And for those of you hospital-based clinicians, your attorneys are probably going to want to see these things. And the sad news about it is that, again, the manufacturer's hands are tied. They have to show that there is a good side to this, and there is. But the lawyers have to show that there are questions about these things. So you'll be hearing more about REMS in the future, but that's enough to scare you into something. Nobody really knows where you are. Patient accountability, I'm going to skip over this. The thing that happened with CMS this summer, Centers for Medicare and Medicaid Services, there have been many allegations and supporting data for abusive and fraudulent billing of urine drug testing services at the point of care and at the laboratory level. And CMS is in, and I know this because I'm involved in discussions with CMS and dealing with various companies that are before CMS, and I'm not going to take any platform position, but I'll tell you right now, CMS believes that much of this was started by the laboratories that have gotten into the pain management world and marketed about the financial gains that can be realized and marketed about the amount of testing that has to be done from a risk management perspective. So they've driven up the utilization in this area. I wrote to the CMS yesterday that that's only one part of the equation. The other part of the equation is that everybody in this room has been under a tremendous pressure to balance and do risk management stuff and, guard against misuse and diversion. And there have been prosecutions that people are afraid of. And so the whole pain community is also responding to that, which can drive up utilization, because if you look at the chronology of publications that discuss urine drug testing and pain management, they too have grown over a period of time. So we're not, again, talking about people doing things on the education side simply to make money. We're talking about a natural result, education tied to changes in legal regulatory material and clinical standards or guidelines in this instance. So they're upset. They are going to change the codes. The codes will result in a reduction of financial impact on at least the federal system here as it relates to both point of care and laboratory testing. Except the CMS only received the laboratory side in this hearing. There were no representatives of the physician side at this hearing, and their comment period closed yesterday, and I would wager to say most of these people in this room had no idea this was going on. Fair statement? Okay. Well, I wrote a letter, others wrote a letter, and it simply says, look, clinicians' discretion must be preserved in this area. And if the platform is point of care only, or lab only, or a combination thereof, it must always be backed up by medical necessity and solid documentation of good clinical judgment. And if a practitioner interprets guidelines and regulatory policy to requiring more upfront evaluation of the patients, then they're probably right, because that's the shift that's happened from a regulatory and clinical perspective over the last 6 or 7 years. And I said that no matter what CMS does with these codes, they need to take this step to tell these people that are marketing inappropriately to back off. because misleading information is as fraudulent as the billing that occurs with it. It's unfair, and it's not right for anybody in this pain community. And so you can read the letter that I wrote. I didn't post all the attachments with it, but in the end, I think that there will be some significant documentation that comes out of this, and I would not be surprised if you don't see a special fraud alert from the U.S. Department of Health and Human Services, Office of Inspector General, on inappropriate marketing and billing and reimbursement items associated with any type of laboratory services. Urine drug testing will be the translation. Okay? CMS can't tell you not to do it, but they can tell you they're not going to pay for it, or they're going to limit the amount of money that's applied, and they are a little bit behind the 8 ball in terms of the education that they have. They need education and before they can educate others. And the OIG gets involved with mass fraud alerts very rarely, but when they do, it's usually tied to the inducements that come in connection with point-of-care testing, get the screen, send it all to the lab, or send all these things. And that's where the bad relationships are from CMS's perspective. So there we go. I'm out of time, and I just want to show you some medication education. One of the smartest things you can do in clinical practice is go and get government-free information on things like a guide to safe use of pain medicine. Blow it up, put it in your waiting rooms, put it in your patient encounter rooms, give copies to patient, and document in file. Why would you do that? Because if somebody looks at the file and says you're not doing enough education on informed consent, items like this, and ultimately the REMS documentation, will really serve to back you up. And they are good materials to help patients understand the real issues there. So we don't want the chickens horror movie. Listen to what Jennifer said, and there's my contact information. Thank you very much.
Now we have 15 minutes for you to answer questions.
Oh, okay.
Time for some questions, but one quick thing in the appendix are those guidelines from the American Pain Society. So we have that available for you in the back of your handout.
And they'll also be uploaded on the intranet and all these other materials as well, so you don't have to go killing trees to get to them.
What can you hear? What constitutes a controlled substance?
Is that turned on?
I heard it. What constitutes a controlled substance? Controlled substances are defined by, first, the federal law, the Controlled Substances Act, and though I'm sure you know this, they're placed into schedules. The lower numbered the schedule, like 1 and 2, the labeling is tied to the potential for abuse and whether or not there are current accepted clinical indications for use. So those items in Schedule 1 have the highest potential for abuse and don't have any current accepted clinical indications for use outside research areas. Items in Schedules 2, 3, 4, and 5, as the numbers go up, the viewed or perspective on potential abuse goes down. The potential for that goes down. The federal government is only the platform. The states can then schedule more strictly. So many states, the federal government doesn't schedule, for example, tramadol or carisoprodol, but many states do or are starting to do so because they are experiencing abuse and or diversion problems in their own state. And so a controlled substance is defined by the federal government. Several different agencies are involved with scientific backup and placed into the schedules, making them controlled. Making access to them controlled.
Is it just for narcotics or all kinds of?
Well, benzodiazepines are controlled. I can go through a litany of them. Many different medications are controlled, meaning the access is limited. So it's not just narcotics.
Speak
I couldn't
loudly
hear.
if you're going to talk.
I can't hear what everybody's
Yeah,
saying, so.
right. You guys needed to ask questions one at a time.
I've got a question. Okay, I've got a question over here. This is an area that we haven't covered, but I talked to Dr. McCarlberg about at the break. I'm in both addiction and pain fields, and Dr. McCarlberg and I were talking about the use of Suboxone for pain, and we both agreed we've had positive experiences in using Suboxone. We've obviously, in the addiction patients, we've had a positive response. We've also had positive response in using it for pain.
Right.
Now, my question to the lawyer is, the red flags, warnings, cautions that a practitioner should use to use the Suboxone for both addiction and pain.
Okay, that's a really good question. How many people in this room are X-registered? All right? When you're X-registered, you agree to follow certain rules, just like when you're regularly registered with DEA. And when we have a medication like buprenorphine, Suboxone, the various forms of it, there is a labeled indication and an off-labeled indication. The DEA gave the ability to conduct the office-based treatment of opioid addiction using this medication because you couldn't do it with methadone. You couldn't prescribe methadone in your office to detox or maintain, but you can take Suboxone, etc., and do that. But with that permission slip comes limitations. And the first limitation for the first year of qualification is you can only do 30 patients, all right? Then you have to file a waiver. And that waiver says you intend to go up and you're qualified to 100 patients. And then DEA says that you can't go above the 100 patients, and you have to keep track of all of your, dispensing and administering of the medication as you go through the induction phase and all the other stuff attendant to that, and keep the paperwork. On the other hand, as a regular registrant, you're not required to keep quite as much paperwork when you prescribe controlled medications just generally. You're required to keep track of what you're prescribing, right? And then states add to that, but DEA doesn't require what your patient files look like. So therein lies the problem for the ex-registrant, who also happens to treat pain. DEA pretty much guarantees an audit of ex-registrants within a year or two of getting that ex-registration. And they monitor the use of that medicine through the pharmacies that are dispensing it, or if you're dispensing in your own practice, you have a pharmacy, and they want to see if the numbers and the way that you're writing the prescriptions on the X side truly match up with detox and maintenance. They look similarly at the pain side, and if they see anything that would indicate that you really are detoxing or maintaining a pain patient, and they should be in your number, your counted number over here on the X side, then that can trigger an audit. That's their concern, that people will hide and really be doing 200 people instead of 100 by having the rest of them on off-label use of the medicine on the pain side. So it can guarantee an audit. You need to make sure your paperwork's in order. The company, Reckitt Benckiser, that does a lot of the training for the X-registration has a good guideline and checklist for this information on the X-registration website. ASAM has that, American Society of Addiction Medicine. Lots of places to get that information. And then double check and make sure that you are very clear in your orders of that medicine for pain. And whether it's good or not, I mean, I've heard that anecdotally from clinicians, but I'm not a clinician.
Right there.
We looked into, doing the testing, screening in the office, and even if you get the CLIA thing, you still cannot you cannot test waived for methadone or buprenorphine. Is that going to change with what you were talking about?
Well, the question
you
is
have to
about
use a
doing
lab.
point-of-care urine drug screening. The real problem with, and first of all, let me make this clear. It is perfectly legal to do point-of-care urine drug screening in any medical practice, so long as you have the right paperwork. So part of that is a CLIA, certificate of waiver, or certificate that covers moderate or higher level complexity testing depending on the nature of the physician's office laboratory, okay? It's easy to get the right paperwork in place. What's harder to understand is the billing component to point-of-care testing, no matter what it is, and it needs to be accurate. And then there's the other thing that overlays it. Even if you get your billing and coding accurate, science and billing and coding don't match up. And so in the science of urine drug screening, we still are lacking the ability to get some reliable information on certain drug analytes, okay? You've raised methadone and buprenorphine. There are point-of-care screening kits that have those on there. And it raises the question of reliability. Can they be billed for? How do you bill for them? Do you always order all the tests if you get a positive? Should you always confirm all negatives? And it gets into what I call really dangerous ground if you do not understand the legal and reimbursement issues around that. Because, forget the science for a minute. The battle with CMS right now is over potential abuse and fraud of the federal funds in the Medicare and Medicaid system. And when they get upset about that and they get an area where there's been such widespread abuse, they start just axing and slashing. And people like you that are trying to do it genuinely and really do the right thing for your patients, both at the point of care and with the traditional laboratory, get caught in the middle. And so the answer is, hopefully, what's happened here will bring science a little closer to coding. And will level the playing field so that this argument of point of care is illegal or laboratory's best or you have to confirm this or confirm that will go away. That they will set those boundaries in general for you, and then with the help of legal and reimbursement experts, get it right. So you can say, company rep, go away. I'm going to figure this out on my own first, and then I'll come to you, because if the rep is still pressuring you, then there's an issue. That should be the biggest red flag you have. Because there are legitimate companies out there, and then there are ones that are in trouble with OIG, and that will be made very apparent in the next 6 months.
Okay, and unfortunately, in terms of time, we need to
We're
move
out.
on, but we will have, we will have,
I'm going to be around too, so
yeah, we have time this afternoon for questions. And our next speaker, Ethan, it turns out to be a long-lost cousin of mine. I hadn't realized that. Yeah, I want you just to get up there. Ethan comes to us from New York, and he is the founder and executive director of the Drug Policy Alliance, and turns out to know half the people that I know. So,
Okay. Can you hear me? Yes? Yes. Good morning, or good noontime. It's really an honor to be here. This is my first time in Montana. I wish I could stay longer. I've just already had very good vibes and everything while I'm here. And it's also a sort of funny day for me to simultaneously a Rosh Hashanah, the Jewish New Year. So I spent this morning at the Bozeman Synagogue. I didn't know there was a synagogue in Bozeman until this thing. And it's also my daughter's 21st birthday today. And so it's a special day. But it's a nice day to celebrate in Bozeman. How much time do I have?
You have 45 minutes to speak and then 15 for questions.
Okay, and I will lose sight of the time. Hopefully you will as well. So just somebody should wave at me if it goes too long. But what I want to talk about here is it's the way we deal with drugs in our society, quite simply. It's how we deal with drugs, how we deal with alcohol and heroin and cocaine and methamphetamine and tobacco and nicotine and pharmaceutical opioids and marijuana and you name it. Because my own sense about this, and I think many of you will agree, is that there's something fundamentally wrong with the way we're dealing with psychoactive drugs in our society. That we somehow seem to have figured out ways to make a disaster of this process. That we have introduced over the last century the criminal justice system and the criminal law in a way which to my mind appears to be doing a lot more harm than good. And meanwhile, we've adopted and embraced different types of mentalities, of ideologies about these drugs and about these various drugs that remain sort of critically unexamined. And that these things dovetail in various ways that really have led to unnecessary death and suffering and loss of freedom and degradation of things we care about in this country that cannot and should not be sustained. That's basically what I'm talking about. And I should say, so let me just say the first thing. I mean, my background is I was an academic in the late 80s, early 90s. I taught at Princeton. I started speaking and writing about this stuff. Before that, I did research. I'm more on the law. My degrees are in law and political science. I did background in, I worked in the State Department's Narcotics Bureau as a consultant many years ago and wrote a classified report for them about their efforts to enforce America's drug laws. I got to know the people on the side of the enforcement side. I don't demonize the people who are involved in the enforcement stuff. But I've also landed up spending much of my life, and I expect the rest of my life, trying to build a movement, a political, a social movement to change the way we deal with drugs in our society, and not just in America, but around the world, but especially in my country and your country right here. And I feel in a way that this is a little bit like a calling, that this is something I'm meant to do. I built what's now the biggest organization in the world, the Drug Policy Alliance, of people advocating for this. We lobby, we engage in the courts, we engage public education, the media. I pick up the Bozeman paper today, you'll see something in there. It's all about changing the way people think about these things and about changing the laws and policies that we live under. And when I'm out there speaking, or my colleagues are out there speaking, one day it may be, for some, you guys are a pain conference, and by coincidence last week I spoke at the annual conference of Pain Week. And I haven't, but normally I might be doing grand rounds one day and speaking to prosecutors or criminal defense attorneys the next day, and going to a university the next day, and businessmen the next day, and going internationally and talking, whatever it might be. Because in a way, of course, this issue touches all of our lives. It does touch all of our lives. And I should also say that when I'm talking to you here, I'm not just talking to you as professionals in the field of pain management. Nurses and doctors and others engage, whether it's in the use of opioid medications or alternative medications or some combination. I am going to talk to you in that guise. But I'm also speaking to you as fellow human beings and fellow, in most cases, citizens. Because change happens not by just what we do, the 9 to 5 or the office thing. Change also happens by what we do in our own personal lives. Change happens by what we do on the weekends and what we do in our social encounters. Change happens by what we say on the chance encounters with politicians, and whether we pick up the phone and call the talk radio, and whether we write a letter to the editor newspaper, or in all the sidebar conversations we have with our patients and fellow practitioners, and the other parents from our kids' school, and wherever else it might be. So it's in all of those senses. And I'll also say that, my own experience, because I regard myself first and foremost as a teacher, that my own experience is that people learn best when they get a little uncomfortable. That if I make you too uncomfortable, I know you'll just shut down and close out. But if you just sit there and nothing's happening in here, if I'm not bugging you in some way, stirring something up, saying something that seems to be hitting a spot that felt a little unguarded or unprotected, then I'm probably not doing my job. And all I can ask of you is to stay open to that. That when you start to feel me challenging you or saying things to you or asking you or pushing you, just don't close down. Stay open. Part of what I'm trying to do here is to plant the seeds of some other ways of thinking, some of which you've already thought about, some of which you're already doing, some of which maybe you haven't, and some of which maybe you disagree with now, and maybe I'm wrong and you're right, but at least give this some thought. Because when I look at this broader, so many of you are, how many of you, by the way, are involved in the issue of either prescribing or administering opioid medications? Just raise your hands, please. Okay. And how many of you are involved in dealing with pain through ways other than opioid medication, through everything else, basically? Okay. So, there's this way in which you lie at this pivotal place. You've been placed in the role of being the administrator and the gatekeeper of these precious substances, right? These pharmaceutical opioids in most cases and some other things. It's a role that was not always your role as physicians and nurses 100 years ago, for example. This gatekeeper role has emerged over the last century, and you've been put in that role, put in a role where you are expected to play ball with the law enforcement system, where they look over your shoulder, where they count on you, and will go after you if you don't play ball with them in a way. I want to challenge that basic idea, but part of what I want to do is put it into the broader context. America's drug war, I believe, is one of the most fundamental violations of human rights in global society today. Okay? And let me just reel off a few stats, but I'll put them in some perspective so that I think you can get it. We in the United States, we are less than 5% of the world's population, but we are almost 25% of the world's incarcerated population. Okay, roughly 300 million out of 6.5 billion or so. We rank first in the world in the per capita incarceration of our fellow citizens. First in the world, right? The Russians keep huffing and puffing trying to beat us. We have left them in the dust. We are number one. And we lock up people at a rate that is 5 to 10 times the rate of most other countries in Europe, Canada, what have you. 5 to 10 times the rate. Ask yourself, why? Why? Are we so much more evil than other people? Is that what's going on? But quite frankly, if you look at it, our rates of nonviolent crime are roughly the same as a lot of those other societies. Our rates of illicit drug use, despite what you hear, are not that different. A little higher, but in some cases a little lower than a lot of these other societies as well. Our rates of violent crime are somewhat higher, but that's not who's filling the prisons. Right? What we do in our country is we are faster to put people behind bars. We almost regard it as a moral imperative to put people behind bars if they violate one of these laws here. Once they're behind bars, we keep them behind bars for longer than almost any other society does. And once they come out, we make it much more easier to throw them back in for a dirty urine, a failure to show up with your parole officer, whatever the thing might be. And we treat them as second and third class citizens oftentimes for the rest of their lives. They may not be able to vote, or it's hard to get the right to vote. They may not have access to scholarships or to public benefits or housing or for food for their kid. They may not have access to, they may not be able to get a license. You can be trained to become a barber behind bars, and then you can't get a license to become a barber. I mean, ludicrous, crazy stuff. Now, we have developed a form of exceptionalism in this regard that we're not aware of. When we talk, and when more and more people now are talking about sort of prison reform, criminal justice reform, yes, we have too many people behind bars, we can't afford it anymore. Building new prisons was the fastest growing item in the Montana state budget and many other state budgets in the 80s and 90s and into the last decade. But what we do is when we look for reform, we go, well, let's see what that other state is doing. Let's do it. And that's a good thing to do. It's a good thing to do because you guys are about roughly in the average when it comes to per capita incarceration. Maybe a little below average, but about the same as my state, New York, right? But we don't stop to think and step back and go, what's the rest of the world doing with this stuff? Why is it that other countries, roughly similar rates of nonviolent crime or drug use, that they have 1/4, 1/5, 1/7 our incarceration rate? And by the way, it's not because they're all culturally or racially homogeneous. Now Europe is a hobgob of immigrant populations. You read all the stuff in the newspapers. It's getting as diverse as America is. And with all the ethnic and class issues and poverty issues mixed in, it's not like homogeneity city. I mean, maybe Japan to some extent, but not much of the rest of the world. It's understanding that we're doing something here and we've lost perspective. We've lost perspective on our tragic exceptionalism, our reliance on the criminal justice system and incarceration in a way that no democratic society in history has ever done, and that no other society around the world today is doing. That we are incarcerating people at a rate that exceeds or approximates the rate of incarceration in the Soviet gulags of the 30s and 40s and 50s, and that the rate of incarceration, especially of African American, dark-skinned men in this country, vastly exceeds the rate of incarceration in the Soviet gulags or apartheid South Africa. And that it's not just incarceration. It's not just those 2.3 million people behind bars tonight in a local jail or a state or federal prison. In addition, it's the over 5 million people in the supervision of the parole and probation systems, right? Also, I think that's also an area where we have the highest per capita parole and probation rates in the world, right? A surveillance of 7-odd million people in this country. Now, this has also been a dramatic increase. In 1980, it was 500,000 people behind bars. Now it's 2.3, a quadrupling effectively, right? Ask what's driving it. Not only is the mindset that, yes, prison's there to punish people, and that if you break a law, you must be punished, right? Not only is it because we lost sight of the notion that our number one priority should be to keep nonviolent people out of prison, if at all possible, to find other ways to hold them accountable, to find other ways to punish them, but to do whatever we can not to put people into these prisons where they are exposed to other criminals, oftentimes real criminals, where they come out with a criminal record, where their chance of getting employment is automatically reduced dramatically, where they've severed relationships with families and kids, where we've derailed them oftentimes for life. It's not just that. It's also our mentality around drugs. It is the drug war. It is the presumption that criminalization and the criminal justice system must be front and center in dealing with drugs. Not all drugs, not, booze. There it's only if you get behind the wheel of a car and you're drunk. It's not tobacco or cigarettes. I mean, we're inching up that way, and maybe if you light up in a kindergarten playground, they might arrest you, but we're not there yet, right? But on the other hand, these other drugs, marijuana, cocaine, heroin, methamphetamine, blah, 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 I mean, unless they got some kind of prescription from some of you, which sometimes you can't even get any of these things, well, they're a criminal. They're a criminal. And we don't distinguish between the non-destructive use of drugs in our law and the highly destructive use of drugs. We don't distinguish between the harm that one does to himself and the harm that one does to others in these things. We don't distinguish. We treat the person who simply uses a drug in the privacy of their own home the same as a drunk driver under our criminal laws. Sometimes even more. Sometimes the penalty for possession of an amount of methamphetamine or marijuana or heroin or a pharmaceutical opioid without a prescription in the privacy of your own home gets punished more severely than the drunk driver who could be on the road and putting our lives or our children's lives at stake. That's bizarre. I haven't stopped to think about it, most people, but that is the nature of this law. There were 50,000 people behind bars for a drug charge in 1980. There are now 500,000 people behind bars today for violating a drug law. Let me put that in some perspective. We're locking up as many people for violating a drug law today as we locked up for everything in 1980. And our population hasn't grown that fast. We're locking up more people for a drug law violation in America than all of Western Europe locks up for everything. And they got 100 million more people than we do. So just some perspective on this stuff, okay? The question is, what's driving some of this stuff? And how do we turn it around? And where do you all fit into this? Now, the first thing I want to make clear is when we ask this basic question, when we ask why was it or how was it that we landed up with alcohol legal except for that 14-year period in our history of alcohol prohibition? Why is it that cigarettes are basically legal, and even as we cramp down effectively and hopefully more effectively to reduce smoking and all its ills, we're not going to move towards prohibition? Yet these other drugs, marijuana, cocaine, heroin, et cetera, are all illegal? Is it because some early version of the National Academy of Science, Institute of Medicine got together in the early part of the last century and all the leading experts and scientists got together and say, well, we've concluded that in fact these drugs are very dangerous and these drugs are not so dangerous, and therefore these ones won't be treated as a criminal issue except, but these ones will always. Does anybody believe that that's what happened? No, of course not, right? I mean, there never was. If you read the transcripts in 1914 of the Harris Narcotics Act, read the transcripts of when they criminalized cannabis or other drugs in the state legislatures in the subsequent decades, I mean, you think you're reading a Monty Python routine. I mean, it is a mockery, right? You see the testimony of people from medical associations. You see the major, New York Times, elite news. You can't believe what you're reading. Who were the principal users of opiates in America in the 1870s? By and large, middle-aged white women. Middle-aged white women. Going through menopause, and they didn't have Motrin, right? And they didn't have aspirin, and they didn't have Bayer aspirin until 1898, and they didn't have penicillin, and they didn't have all sorts of other things. Bad sanitation, especially in the South. People had diarrhea all the time, and nothing like those opiates to stop it up. So, I mean, there was, and it was widely used with a doctor's recommendation, without a doctor's recommendation. You didn't need a prescription. You got it by mail. You got it at the local grocery store, divided in the form of laudanum. It might be administered in the form of morphine. Many people would take this stuff. They did it every single day. They didn't even know they were addicted in many respects, no more than we think of ourselves being addicted to coffee until for some reason there was a reduction in supply or they couldn't afford it. And then they would notice it again, kind of flu-like symptoms and shakes and all this sort of stuff. Or during the Civil War, when there was a cutoff of supply, people realized it. right? Yes, were there people who overdosed? Yes, those were problems, right? Millions, hundreds of millions of parents all around the world, from England to America to Canada to India, what did they do with their baby who was teething? Took a little tiny bit of that laudanum and rubbed it on their lips, and it worked fantastically in 99 point whatever percent, and then there were always stupid, foolish, ignorant parents who gave too much, and you would have a few dozen fatalities around the world as a result of the maladministration of this stuff. But by and large, the percentage of people consuming opiates for primarily medicinal, quasi-medicinal, whatever reasons, was probably greater then than it is now. And there is no hard data on that stuff, but there is some reason to believe that the percentage of people dying as a result of opiate-related overdose, drug combinations, was probably less back then than it is right now. Right? When it was out, there was no controls, there was no regulations, right? They didn't have as great a diversity of these opioid things, right? But I mean, and nobody thought to make it illegal. Why? Because nobody thought to put grandma behind bars just because she was using something that some people had a moral objection to, right? Now, however, when the Chinese started to show up, maybe in Montana, I know in Nevada, in California, working in the mines, on the railroads, working 80, 90, 100 hours a week, going back to their tents or their dormitories at the end of the night, maybe their opium den, smoking up a little opium pipe just like they had in the old country, just as they had for hundreds of years. And people began to worry, oh my God, those opium dens, what are those Chinamen with that smelly opium? They're going to seduce and addict our white women and turn them into opium slaves. And we got the first drug prohibition laws in America in the 1870s, 1880s in California, Nevada. The first anti-cocaine laws, right? Cocaine in Coca-Cola till 1900. To my knowledge, no massive Coca-Cola addiction problem in America before. I've never read about it. Maybe it was, right? You had cocaine, and yes, you had people begin, because with the development of the pharmaceutical syringe in the mid-19th century, there were people injecting and doing bad things. I don't think there was crack, by the way, even though cocaine was amply available. I don't think people were really smoking that stuff back then, right? But people were not talking about making this stuff illegal until it started to be used by black men, by Negroes in the South in the first decade of the century on the docks in New Orleans, taking this white powder up their black noses, and who knew what they might do to our women and our children, enraged and powered with this cocaine, right? That's when we got the first cocaine prohibition laws. You read the stuff the New York Times, of all places, my favorite newspaper, wrote about this. I mean, the racism just kind of leaking out the sides of the coverage of this stuff. The first anti-marijuana laws in the teens and the 20s. Directed at Mexican Americans, Mexican migrants coming up, to the Southwest, the Midwest, taking good jobs from the good white people, going back home at the end of the night, smoking up a little of that funny smell, reefer cigarette, la cucaracha, right? And that's people started for these dark-skinned people smoking that funny thing and having a good time. And what might they do to our women and children? Let's make it illegal. First cannabis prohibition laws in the teens and the 20s at that time, spreading to the rest of the country. And then 1937, Congress does it as well. It's always been about who uses the drugs and who is perceived to use the drug, right? That's what distinguishes how we treat these laws, these drugs in our laws. Even, quite frankly, alcohol prohibition. I mean, alcohol prohibition, to some extent, was about a broader social conflict between the white Americans and the not-so-white Americans, right? The white Americans coming over from Northern and Western Europe in the late 18th and 19th century, and the not-so-white Americans coming over from Southern Europe and Eastern Europe in the late 19th, early 20th century, flooding into our countries the way the Mexicans and Central Americans are today, and freaking everybody out, and bringing with them their beer and their vino and their Schlibowitz, right? I mean, it was that cultural conflict. And it's not as if the white Americans weren't drinking. It's just that there was also an understanding that even if you were drinking, you were not going to be the target of these criminal laws, right? That inevitably, that when you punish a behavior like this, a behavior that is widely violated, widely engaged in, then inevitably there will be discretion in the enforcement of the laws. I mean, the classic mistake that African American leadership has made in this issue over and over and over and over again is coming out of the black churches and believing in the immorality of various behaviors that they believe are prohibited from the Bible, right? And then calling for prohibition laws without ever thinking that every time they invite in a prohibition law, they are ineffectively inviting in a disproportionate targeting of their people, of African Americans, for the enforcement of these laws. That's always been the case. It's always been the case. Criminalize something that many people will do, and some people, the cops are going to look right through or not target on it unless they're very unlucky or stupid or whatever. And other people, cops are going to be all over them, all over them. Even if the rates of drug use are equal across these groups, that group's going to be disproportionately targeted for all sorts of reasons. So these laws that you are smack in the middle of being quasi-enforcement agents for, they don't have any scientific or intellectual legitimacy in the beginning. You have been, I mean, they may have existed since you were born and before you were born, but their only legitimacy is from their longevity. They don't derive legitimacy from their origins. They don't derive legitimacy from science. They don't. It's not there. So the question is, when you're involved in this process, what role are you supposed to be playing in all of this sort of stuff? What is this role of pain? Now, I sometimes hold you guys out as role models because you are, in some respects, more advanced and more sophisticated than, and more flexibility than people dealing with addiction to opiates, addiction to heroin, right? Sometimes when I talk to people involved in the field of addiction treatment, I'm trying to get them to open up, especially with respect to addiction to opiates. And I'll say, if you go to a doctor, or you're going to a doctor because somebody you love is in profound pain, and the doctor says to you, well, what would you prefer I prescribe? Would you prefer that I prescribe fentanyl or Dilaudid? How about Demerol? We could do methadone, it's cheaper. And the patient's going to say, doctor, I don't care. I want you to prescribe whatever is going to work best. And work best usually means reduce the pain as much as possible while maintaining their basic humanity, personality of that person, right? That's the basic objective, I believe. Am I right? Is that basically the objective of what you're striving to do? And then if the doctor says, well, how would you like me to administer this? Would you prefer I do it by injection? We could do it orally. We could do it by a patch, a patient-controlled analgesic. We even do lollipops if it's, And you say, doctor, I don't care. All I want you to do is to focus on the bottom line. Reduce the pain as much as possible. Enable them to be as much themselves as possible. That's the bottom line, right? Okay. And I imagine that many of you hold that out in some respects as your ideal. I think, I hope. Now, and part of the reason I'm saying this is that when you're coming to treating, say, heroin addiction, we know that methadone maintenance, done right, with adequate dosing, with people who are respectful. If you have a methadone program, which always believes that less is more, which only hires people in 12-step programs who have contempt for people in methadone programs to work in those things, right? If they're kicking people out because they're testing them for, you tested positive for marijuana, you're out of here, you tested positive for this. That's not methadone maintenance treatment. That's something else pretending to be methadone maintenance treatment. But when it's done in ways consistent with the scientific evidence, in ways consistent with global practice in this area, with respect for the patient, focusing on the bottom line, well, then it works. But what we know is that even though methadone may work the bestest for the mostest, it's not going to work for everybody. We know that for some, buprenorphine is going to work better. But in Germany, in France, Germany, they were doing codeine maintenance. They had a ban on methadone until a couple decades ago. They were doing codeine maintenance for 50, 60, 70,000 people, and it worked. And there have been other places in our country, in our history, of doing morphine maintenance, right? And then, of course, there's the experience with diamorphine, AKA heroin, right? Now, the British had always recommended this stuff, been able to prescribe this stuff with some flexibility for people who couldn't quit. But what the Swiss began doing in the early 90s, they took people who had tried methadone maintenance, hadn't worked, been drug-free, hadn't worked, been in jail, hadn't worked. These were people who were getting to a certain age where, heroin had become the love they couldn't live with and the love they couldn't live without. They had gotten to a point in their lives where they didn't want to be hustling on the streets anymore, but they could not imagine living without their dear, precious heroin. They weren't even getting high that much anymore. It was just to keep from getting sick at this point. And the Swiss said, let's try an experiment. Let's set up clinics where you can go in there and you can get pharmaceutical heroin up to 3 times a day, can't take it home. You know, we'll give you your baseline methadone, we'll give you other meds, if you got HIV, whatever, Hep C, whatever it might be. We'll try to help you in terms of stabilizing your lives, like a very well-run methadone program, but also allowing pharmaceutical heroin and not allowing it to be taken home. And the Swiss found they did this. First in Zurich, then it spread around the country, even small towns, not just big cities. You know, they found that, in fact, it was remarkable that people started not only reducing their illegal heroin use, they started reducing their other illicit drug use. They started withdrawing from the black markets. They stopped getting arrested already. They stopped being involved in sorts of crime. Their health improved. Their sort of disease prevention behavior around HIV, Hep C improved as well. Some of them began to get jobs, right? There was this incredible stabilization in their lives, right? I mean, then the Germans started doing it, and it worked there too. And the Dutch, and it worked there too. They also tried it not just with injectable, but smokable heroin, which is how some people do it there, chasing the dragon. And then the Spanish did it, and then the British did it, and now the Canadians in Vancouver and Montreal have just finished their NAOMI study, North American Opiate Medication Initiative, and all of them are consistently showing the same results, which is that when you take people who have tried in other ways to stop and they can't do it, and you allow them into this program, what you find is these people are able finally to stabilize their lives for the first time. The cops who were irate when they started are now the biggest champions. Remember that 60 Minutes did a wonderful thing on this 10 years ago. If you want it, I'll send you a copy and give you my card later. You know, and they found that the police chief said, I thought this was the stupidest thing when I ever heard about it. Now I'm its biggest supporter. Why? Because it reduces the acquisitive crime by drug addicts, it reduces the black market, and it actually helps these people, I've come to understand. Right? I mean, that was it. 10 years ago, the cover of Der Spiegel magazine, the German Newsweek, majority of German big city police chiefs now support heroin maintenance, right? For the same reasons. Now, I'm deeply involved in trying to get this. I tried 10 years ago to get this going in America. We got the Canadian leg going, and the Canadians ran with it, got funding. Now, under the new Obama land era, let's try to move this thing in this area. But what stands in the way? What stands in the way is not science. What stands in the way is not evidence or compassion. What stands in the way is what? It's like, give heroin? Why don't you just give booze to boozers? I mean, why don't you? I mean, what stands in the way is ignorance, fear, and prejudice. That's what stands in the way, right? Now, it seems to me that if we swing this over to the issue of what you're dealing with here on pain, what are you dealing with? First of all, you are dealing with the phenomenon of what I think it was my friend John Morgan who coined the phrase opiophobia, the irrational fear of opioids in our society, right? The belief that we will get addicted, that there's an inevitability to that. The people who come in to see you and say, oh, don't put me on those, I don't want to get addicted. Even if I'm dying, I don't want to die an addict, right? Or who believe less is more, even though the medicine says it's something else. It even is in some of you who practice your medicine and believe in those same things, that less is more or whatever it might be, right? I mean, so we know that that's part of what goes on there, that broader societal attitude about that these opioid medications cannot be used effectively in the vast majority of people. And that it's understanding, for example, the failure in our society to distinguish between dependence and addiction. I mean, to my mind, my definition of addiction is addiction equals dependence plus problems. So you can be dependent on a drug without being addicted. You can be dependent on methadone as a former heroin addict and maybe take it for the rest of your life, and that is the proper medical course. You may be dependent on a pain medication for a long period of time, but you are not addicted to it. You may be a diabetic taking your insulin for the rest of your life, but you are not an insulin addict. You may be taking a hard drug for your heart, but you are not an addict. You are only dependent. And that is a medical definition that can be managed, of which there are no moral connotations, and there should be none because of the nature of the substance to which you're dependent upon. The notion that because you're dependent on insulin, we would never call you an addict, but if you're dependent on methadone, we call you an addict, that's not science. That's prejudice. I mean, let's just be straight out about that. There's nothing about the name of a substance or the identity of a substance that distinguishes dependence from addiction. Now, how does dependence, and you can have a problem with drugs, of course, and not be addicted. You can be the person who uses drugs only occasionally, but when you do, you can't control it. You do stupid stuff. You get drunk and you drive and you get violent, whatever, even though you're not addicted in the sense of always doing it repeatedly. But when dependence becomes addiction, it happens in two ways. One is that the dependence on the drug has consequences for your body. You drink too much booze, there goes your liver, right? You smoke too many cigarettes, there go your lungs and other parts, right? You use cocaine too repeatedly, damage to your heart, right? We know these things, right? You become dependent upon opiates. Well, now explain to me, if you're dependent upon an opiate and you're taking it for the rest of your life, what exactly are the health consequences of that? I mean, you're not going to do your liver, it's not going to do your brain, your lungs, whatever. In fact, what we know is that you can be dependent upon an opioid medication for, in fact, 30, 40, 50, or 60 years. And the principal side effect for many people is going to be constipation. And maybe a little reduced sensitivity to emotional and physical pain that you have to pay special attention to. But it's not like the other things. So what is a heroin addict exactly? It's a person who is dependent upon an opioid medication, otherwise known as diamorphine. Change the name of heroin to diamorphine, and people chill, right? Quite frankly, in this Vancouver heroin maintenance study, you know what they found in that study? They gave experienced heroin addicts in a controlled double-blind test. Some of them got Dilaudid instead of heroin. And you want to know something? Experienced heroin users who could tell the difference between heroin and morphine, heroin and methadone, heroin, a whole bunch of other drugs administered in the same way, they could not tell the difference between pharmaceutical heroin and pharmaceutical Dilaudid. Essentially saying that Dilaudid is heroin and vice versa, quite frankly. But people don't freak out when you say Dilaudid. It's one of the medications you guys prescribe. But in fact, among an experienced street-using population, they couldn't tell the difference, right? So dependence becomes addiction, either because the drug is damaging to you, as with alcohol, cocaine, cigarettes, right? Not necessarily nicotine, right? I mean, you can be on nicotine maintenance that you slap that patch on, you know, oh yeah, that's supposed to help you get off cigarettes, and 5 years the patch is still there, right? You're still whacking away at the chewing gum, for 12 years, right? But the fact of the matter is you can be chewing that damn gum or keeping that patch on for the rest of your life, and the principal risk is a slightly elevated cardiovascular risk when you get older. But by and large, nicotine in that form, while it's highly dependence-causing, right, and why it's the hook, the trap in cigarettes, is not destroying you. It's the way you consume it, right? It's the particle matter and what have you. What transforms dependence and addiction, then, is either because the drug itself can be damaging to the body, which is not so much the case in the opioids, or because our public laws and policies are transforming the dependence into an addiction. You may be dependent on an opioid medication, but if all of a sudden that opioid medication can only be obtained from the street, now it costs 5 or 10 times what it would otherwise cost. When you don't know the potency or purity of what you're getting because it comes from the black market and nothing resembling an underground Food and Drug Administration has emerged to regulate the quality of drugs on the streets, right? That's when that dependence becomes an addiction. When you are injecting drugs, but you're doing it in back alleys and other places because nobody can see you do it because otherwise you'll get arrested, that's when it becomes an addiction. When you are being thrown into jails and prisons and forced to detox in a brutal way and get back on, that's when it becomes an addiction. It's the ways in which our laws and policies transform a dependence upon a drug into something horrific. And it's also when we add in the imagery and the stigma. Oh, you are dependent, you are addicted, and we transform people's own self-identity. In a way, the addict becomes the person we are telling them they are, right? When you take a group of people and you treat them as crap, when you treat them without respect, when you treat them as demonized, right? When you treat them as second and third class, when black people in this country were primarily treated as slaves, it wasn't just white people who perceived them as slaves, but it was oftentimes black people, black slaves, who perceived themselves as slaves. When gay people are perceived as deviant by the broader world, then they can see themselves that. When women are perceived as second and third class citizens and inferior, as they were for so many millennia, women on some level, even when they fight for their own equality, there's that way in which they believe and somehow accept, because they've grown up and lived in a society accepting somehow their own innate inferiority. When you're talking about a group of people who are using these drugs, whether they're under your administration or obtained from the streets, that sort of societal imagery affects everything, their perception and your perception. And the fact of the matter is that even when you're engaged in pain medication, you can't remove yourself from the broader imagery, from the meth ads out there and from the TV things and the partnership with Drake for America and all of the drug war hysteria and what have you. But it is your obligation to do the best possible job you can on that. It really is. I mean, who's the best pain doctor in the world? The best pain doctor role is like the best of anything in the world. It's the person who approaches the problem, the patient, without any ideology or any prejudice whatsoever. It is the person who knows the most and who has the greatest wisdom and understands the incredible variety among the patients and human beings you deal with, and has no knee-jerk preference that says, well, I'm one who does opioids. Well, I'm one who doesn't do opioids. Well, I'm one who does alternative medicine until the patient's screaming in pain, and then I'll do the opioids. Well, I'm one, and I don't do what I encounter everywhere is this prejudice. This inability. I mean, the best teachers are ones who are wise and brilliant, but they think about what each student needs for themselves. And and the only ideology is the ideology of human rights and compassion and decency. And in your field, the removal of pain, the alleviation of pain, the enabling of people, no matter what it takes, right? There are people in my world, in the medical marijuana world, and they go, marijuana is so much superior to those opioid medications, doctors giving morphine and opiates, all these sort of things. And there's a way in which they're right and a way in which they're wrong. Because nobody's ever overdosed and died from marijuana, no matter how much they took, right? But that is not the case of the opioids, right? The risks, the dangers, the drug interactions, what have you. And marijuana has all sorts of properties, many of which are being understood better and better and better. But what I tell my allies in the medical marijuana area is shut the hell up. Because quite frankly, all the folks dealing with opioid medications are dealing with enough shit from the DEA and the drug enforcement and everybody else. I mean, they are fighting a battle to treat people decently in the face of a drug war context. Like people trying to teach forbidden subjects in a totalitarian society, right? Trying to do the right thing. And oftentimes their medications are going to work better than your medication. Don't put the holy herb on a pedestal and say this is the drug that will solve all problems. It may be a disrespected and underappreciated drug, but don't do the opposite. But I have to say the same thing to you. I mean, there is this wide body of evidence now about marijuana's medical benefits in dealing with nausea and pain and spasms and all sorts of other things. Huge body of evidence. And it's not just anecdotal evidence. It's not just the large numbers of people who are saying, you know, doc, somehow I hadn't gotten high in years, and then I smoked a joint for the first time in 5 years, and all of a sudden those symptoms I've been having, I didn't feel them for a while. I mean, it's not just the zillions of anecdotes that you hear like that, but it's good research happening in the pharmaceutical world, people who are going to win major awards for research on the cannabinoids, Raphael Mechoulam in Israel, who's a leading figure globally on this stuff, the work of Donald Abrams working with AIDS, the University of California, San Diego with its own research program on the medical value, and notwithstanding all the efforts of NIDA and the US government to restrict research and to make it more difficult and require people to jump through hoops, but I cannot understand or one legitimate basis for any one of you here not to be recommending marijuana if in fact that would be beneficial to your patient. There is no legitimate reason. Let's be clear about this. First of all, for those of you who are worried about the consequences of the law enforcement system, right after we won that 1996 medical marijuana initiative in California, which I did not draft, local activists drafted, it's much more wide open than what you have here in Montana or the other states where we drafted them much more tightly. But I'll tell you something. A month later, the drug czar, the head of Health and Human Services, Donna Shalala, the head of National Drug Abuse, all got up at a press conference and they said, we're going to go after the doctors and patients who talk about marijuana as medicine. And we joined with the ACLU, Drug Policy Alliance, and the ACLU. We got together and we took them straight to court. And we said, you are violating the First Amendment rights of doctors and patients. And we got a temporary restraining order and a preliminary injunction, and we beat them in federal court, and we beat them in appeals court, and they finally gave up. We won your First Amendment right to talk about any medication that you think is appropriate with your patient. There is no risk under federal law in your talking about this issue with it, and there is no risk in your writing in a record, I have reason to believe, based upon my consultation and my examination of the patient, that marijuana could be medically beneficial in this case. There is no basis in law, and you can hold up this case. I'll tell you something else. Shortly after that, my organization, the ACLU, each received a check for about $350,000 from the drug czar's office, reimbursing us for attorney's fees in our case. That was, I will tell you, the sweetest contribution I ever got. But we did win that right. So maybe you worry about the scuttlebutt and what other people are going to say, but if your bottom line is about helping your patients and serving your patients, then you do not have a right to be ignorant of that evidence. And you do not have a right to say, I don't do that. And if you work in some kind of healthcare program or a hospital system that requires that pain patients be tested for drugs, not for their own so that you can prescribe, but to punish people. If you work in a program that says that we will take people off their pain meds, whether it's addiction program or pain drug, if they test positive for marijuana or even some other drug, that is malpractice as far as I'm concerned. There is no legitimate basis for taking people off their medication if they happen to be using marijuana as well. And what you know is that there are no medical risks associated, because one of the fortunate things about cannabis is that you cannot overdose no matter what you combine it with. You may get sick, dizzy, nauseous, but you are not going to die from that stuff. Combine the opioids with other things, the tranquilizers, booze, you may, but you are not. There is no basis not to include this. And given the wide base of evidence that is out there, there is no basis whatsoever. I will also say, you got to be kidding me, 1 minute left? Ooh, I was just getting going.
Keep going.
Keep going. Okay. Okay, because I do want to throw out some more ideas to you about this stuff. I also think this whole issue with diversion, where you are smack in the middle and you've been put in the place of, you got to make sure that that patient's not trying to scam you and he's I think the most courageous people working in the field of pain management are the people who are doing pain management with people who have been addicted to illegal drugs. I think those are the most courageous people. And of course, I know that some of the people who get into that are people who are a little quirky. You got to be a little quirky to be drawn to that, and therefore they're more vulnerable to having the cops and everybody go after them. But the fact of the matter is, because you become addicted to drugs doesn't mean that you don't suffer pain. Oftentimes, the reason you got addicted to those drugs in the first place is because you were self-medicating in one way or another. Let's face it. So accepting that people have to be is something. You know what? DEA, oh my God. Let me see if I turn this thing off. Maybe that'll help. But dealing with anybody who comes in the door, I also think that this whole diversion issue, yes, it's a real issue, but I think it's so grossly overstated, right? Why? Because there's the internet. I mean, you can get most of these drugs anyway. And these drugs are so widely available that putting you in the place of trying to play the gatekeeper there and trying to suss out the intentions and motivations and trying to be concerned about giving too much, because why? I mean, I actually think that our whole law enforcement system suffers from another disorder of its own sort. I call it diversion obsessive disorder, DOD, right? I mean, because it's overstated. Your role as gatekeepers is misplaced. It seems to me your role should be first, second, and third about dealing with your patient and doing everything you can to ensure that their pain is being managed, and that those other roles should not be a major part of your preoccupation. I also, quite frankly, want to know, what the hell is the DEA doing in charge of scheduling? It's a Drug Enforcement Administration. It's cops. Why isn't the Institute of Medicine in charge of that? Why is the National Institute of Health, the Center for Disease Control, in charge of that? Why is the DEA in charge of that? And who is challenging that basic idea about why cops should? I mean, when you look at something that marijuana is still in Schedule 1, after all these decades, given its relatively low risk and given the evidence, right, it's about politics and not something else, right? There is no legitimate basis for that. In fact, I want to just push you, and this is where I'm talking, because most of my work is on the incremental work. It's working in state legislatures for treatment instead of incarceration. It's about medical marijuana. It's needle exchange to stop AIDS. It's reducing the harsh criminal sentencing. It's about overdose prevention, what have you, right? But there's a broader vision here about accepting the reality of drugs. It's about acknowledging that there has never been a drug-free society in human history, except maybe the Eskimos because they couldn't grow anything. But I mean, apart from them, right? and that there's never going to be a drug-free society, right? That that our children and grandchildren and great-grandchildren live in a world in a far greater diversity of drugs. We're going to have Prozac Generation 8 and Ecstasy Generation 5. And Viagra Generation 29, and neat little combinations. Brain science is going to develop. There's going to be underground chemists and major pharmaceutical company chemists debating more and more and more things. The odds are that the opioids and cocaine and cannabis are going to hang around because they've been around for thousands of years, just like alcohol, and they're going to keep being around as well in various forms. Maybe the consumption of cannabis in the form of a joint will diminish as vaporizing devices become more smaller and easy to use and what have you. Maybe all that will change. But ultimately, I think that our best protection against the misuse of these substances in our society is not going to be by bulking up the law enforcement establishment more and more and more, getting more and more muscular and powerful and intimidating, and our prisons getting fuller and fuller and fuller. I actually think the greatest protection is going to be by the empowerment of the consumer and by the education of the consumer. I think, look, right now, opioid overdoses hit a new high last year. Overdose fatalities, what are called overdoses somewhat inappropriately, but drug combinations involving opioids, is now the number 2 leading cause of accidental death by injury in America after auto accidents. The number 2 leading cause. You guys are there. I mean, there's 25,000, 30,000 people a year. And some of this is out of the drugs that you're prescribing, some is getting diverted, some is black market, some is entirely black market, some is heroin. But I believe that in many states now, overdoses involving pharmaceutical opioids are greater than the overdose fatalities involving illegal heroin, right? You and I know that, like with methadone is cheap, it's remarkably effective, but if you don't use it right, it's a problem. People die that way. Right? You and I know that OxyContin can be a wonderful, fantastic pain drug, and that what happened with people breaking and all this sort of, maybe Purdue Pharma promoted it too heavily and people are breaking it up, but we know is that a powerful medication, effective medication, is being underutilized because of the fears over here. Right? Now I want you to imagine a different world that somehow jumps back 100 years but jumps forward. Imagine if your role, your power to prescribe, was no longer the power of the gatekeeper, but simply the power of the advisor. Imagine if your role was people came to you and said, "Doctor, I need help, I need advice in managing me," and you would thereby recommend which medications to use. But you would not be the determiner of whether or not they could or would not get it. And you would give them a recommendation form for whatever drugs were appropriate or whatever, and then they would go to a pharmacy. And before the pharmacist could hand them that drug, right? It wouldn't be, in a little orange bottle with, do not drink and whatever, do not drive and take these things. Before anybody could get their medication, a little screen would pop up on the pharmacist's table right there with 10 questions about drug combinations, about what to do if you don't, if something happens, et cetera, et cetera. 10 basic safety questions, like a driver's license thing or something, right? For that, and the person, before the pharmacist could give it to the individual, the consumer, they would have to get all 10 questions right. Now, they could take the test as many times as they want until they got it right. But you would effectively be force-feeding consumer education. Right? You would be force-feeding consumer education. This notion of treating every patient in America, no matter their age, their wisdom, as an infant, as a child, this paternalistic approach to these drugs, this assumption that the ordinary human beings cannot be trusted with these powerful things, that ultimately you have to do it, and if you don't do it right, you're going to get in trouble. I don't think that's the right way to go. I think also the issue here of, we're now very involved in trying to prevent these overdose fatalities among people using drugs on the street. Well, there is an antidote, naloxone. How many of you routinely give a prescription for naloxone the same time you give a prescription to pain medication? One? Anybody else? Let me ask you, why not? Why isn't any, I know I've been through a powerful pain experience. I know what you start to do when that pain won't go away and you're going crazy, right? Why aren't you administering the naloxone at the same time? Not administering, giving it. Why aren't you teaching the family members how to use it at the same time? We're also promoting Good Samaritan 911 laws to say that, if somebody overdoses, call the cops right away, just like a heart attack. Don't wait, and the cops won't bust you because it's a Good Samaritan 911 says the police will not arrest. But I want to finish by saying this. Beneath all of this, I threw out a bunch of ideas, right, about your role as gatekeepers, about this broader drug war, about asking and appealing to you to sort of stand up in a new way about this and to think about your own practice. But the bottom line is, I think that there is a core principle behind all of what I'm talking about here. And it's a core principle I think pervades the work you do and the broader way we deal with drugs in our society. And it's this. I believe that nobody but nobody deserves to be punished simply for what we put in our bodies, absent harm to others. That nobody but nobody deserves to be punished for what you put in your body, absent harm to others. Get behind the wheel of a car, that's something else. But for what I put in here, I have to remain sovereign over this mind and body, as do every one of us in a free society. I think that core principle and building our public health protections and our public health notions and public around that notion is absolutely essential to moving into a world where drugs are going to be ever more diverse, ever more available, and where we cannot and where we must not rely on the role of criminal justice to control this phenomenon. That where ultimately it's about dealing with drugs in our society in ways based upon science, compassion, health, and human rights. Thank you.
Okay, so
Thank you. Thank you. Thank you. Questions?
but we got 5 minutes for questions, and then we're going to break for lunch. And remember, bring your lunch back in, because we're going to start in half an hour with a panel.
Yes.
Last year I wrote, and the Washington State Medical Association, thank you, took to the legislature a motion for the distribution of naloxone in a user-friendly manner,
Yeah.
using nasal insufflation,
Right.
little atomizer, to be dispensed by peers who were trained by information on a DVD, failed. Bottom line, soft on drugs.
Right. Now, the legislation like that went through in Illinois. Drug Policy Alliance and other organizations are working on it around the country. If that legislation gets going here, yesterday, Tom Dobert from the Medical Marijuana Organization invited some legislators to sit down with us. One of the ideas they jumped at was doing something like Good Samaritan 911 and maybe naloxone in Montana. So you get behind it, stuff might start to happen here.
We got backing from ACLU, thank you, and we also are reintroducing that measure this year.
Yeah, and there's a fantastic state legislator, Roger Goodman, who comes out of the drug law reform field, who's leading, I think, some of those efforts as well. I should also say, if you want more information, drugpolicy.org is our website. If you want to come to a remarkable gathering, every 2 years there's an international conference on drug policy reform. This year it's in Albuquerque, New Mexico, November 12th to 14th. Not very expensive. Some people in Montana I know are coming down, but you will see a world of people across the spectrum of drug laws, drug use, politics, what have you, all there together.
For inappropriate prescribing, and I don't mean they're dealing or something, I mean they got nailed because the DEA found a little glitch and threw them in and confiscated everything.
Well, yeah, I don't know the data. What I do is I hear the stories that pop up, and sometimes my organization gets involved. Sometimes we submit amicus briefs on behalf of the physician. You all know the case of Bill Hurwitz, the doc in Virginia, who, is he behind bars now? But I mean, who's went through a horrific time. He was an example of somebody who was really doing courageous practice of medicine, but who also wasn't playing ball with the regulators and others in the field. But the punishment was absurd. There are other cases that emerged, but I don't know the stats. I was encouraged. I don't know how you all feel about this, but there was a case a few years ago where one physician was in fact reprimanded for failing to prescribe effective opioid medication. And I think, I know nobody likes legal suits and legal action, but when all the legal action's on one side about physicians who maybe do too much in the eyes of the DEA, I think there needs to be some balance there. But I don't know the stats.
Yes.
For myself, I'm a subscriber of drugpolicy.org, and I practice harm reduction. And I guess the only thing I get a little bit concerned sometimes about these discussions is that, for me, yes, people are naturally going to have a dependence on opiate medications in their care plans, and that's not an issue for me. The issue for me with any substance is really, degree to which they're going to have problems with addiction, where it may affect them physically or spiritually, emotionally, affect how they are in their relationships, that kind of thing. but, so for me, the issue isn't that addiction does develop for a certain number of people. The question is, do we deal with it from a public health perspective? Do we try to provide them those resources? Do we fund those resources? Or do we deal with it from more of a criminal perspective? And I know that for myself, having started in the addiction field in the 70s, it has changed, where before, I started in Washington, it was a public health orientation in Washington. And now, increasingly what's developed is that a person who practices addiction medicine as a therapist becomes an agent of the court a great deal of the time. So it is a different relationship with the client than used to be the case.
I just want to say, I think that's, more and more drug treatment is being incorporated within the criminal justice system at the expense of community-based treatment. More and more, if you're poor and you have a drug problem, the only way to get treatment is to get arrested first, which is really crazy. And the notion of physicians having to be involved in drug testing where a dirty urine means incarceration seems to me fairly antithetical to basic notions of physician-patient confidentiality, as well as basic Hippocratic oath of first do no harm. The notion of drug testing where the testing is only used for therapeutic purposes and not for punitive purposes is pivotal. When we won Prop 36, the ballot initiative in California for treatment instead of incarceration back in 2000, we did not include any money for drug testing. And when the drug court judges came back and demanded money through the legislative process, we were able to weave in their language that drug testing should be used primarily for therapeutic purposes, not punitive purposes, like a scale in a weight control clinic. But what I also experienced, and it was enormously frustrating when we try to push for alternatives to incarceration for people who are addicted to drugs, is that the treatment community self-defines itself as disempowered. That they know they have a role to play, but in a way financially they're depending upon the crumbs coming off the side of the table from the drug war, right? Getting that little piece. And they also define themselves as, well, cops are big and strong, we weak and small. We don't have that role. So there's an element of, it's where people involved in the health side stand up and demand as a matter of principle that things will change, but that self-definition as relatively weaker than others has stood in the way. I also should just say one personal thing. I don't have, as I say, any inherent bias between opioids, marijuana, or for drugs as opposed to non-drugs. I personally, went through horrific experiences with lower back pain and sciatica, L5, L4, L5, L5S1, herniated disc, get the operation, and then a friend of mine, Dr. Andrew Weil, who some of you know, the integrative medicine guy, recommended I read a book by John Sarno. How many of you are familiar with the John Sarno approach? I'm curious. And for me, the John Sarno approach, his book, Healing Back Pain, that was transformative. That turned out to be the thing that worked for me. It got me angry at some of the physicians who were going to do surgery instead. It taught me, it transformed my understanding of the mind-body relationship. It led to me having my own theories that maybe the biggest problems with opioid overdoses right now have to deal with them being used for sorts of pain that may be on some level very real physically, but actually has some psychological underpinnings in a way that's not true of other sorts of pain. But I don't know. All I know is that it's a matter of being ideology-free and with no prejudice or biases about what the medication or intervention is called, and focusing on that bottom line.